Good morning, everybody. My name is Pranav, a legal intern at LEXIS and Company for the month of June. Today, I'll be talking about the mode of determining the existence of partnership or the tests to find out the existence of the partnership. Partnership is the relation between two or more persons who have agreed to share the profits of a business by all or any of them acting for all. So, in order to determine the existence of a partnership, the agreement between them should be looked into. But if there is no agreement constituting the partnership among the partners, then Section 6 of the Indian Partnership Act sets out some rules to determine the existence of the partnership. First is an agreement, which is covered under Sections 4 and Sections 5. Under Sections 4, to constitute a partnership, there must be an agreement between persons. Without an agreement between persons, there cannot be a partnership. Thus, an agreement is the basis of a partnership. Section 5 of the Partnership Act states that the relation of a partnership arises from contract and not from status. The partnership is only a contract. In other words, it springs from an agreement to create a partnership. Second is sharing of profits. Though the following persons share the profits of a partnership business, they do not become partners, who are joint owners sharing gross returns. The joint owners of property who share the profits or gross returns arising of a property do not become partners. Lender of money receiving profits. A person who has lent money to a person or to a firm engaged in business and he has agreed to take in addition to his interest a portion of the profits of the business does not become a partner in the business. Next is a servant or agent receiving profits. Sometimes a servant or an agent of a business is allowed in addition to his regular remuneration a portion of profits of the business, but this does not mean he does not become a partner in the business. Next is a widow or a child of a deceased partner. On the death of a deceased partner, the surviving partner sometimes agreed to give a share in profits to the widow or to the child of the deceased partner. Such a widow or a child does not become a partner in the firm. And the last mode is seller of goodwill. A person who sells his business along with his goodwill is sometimes given a share in the profits of the business, but such a person does not become a partner in the business. Now let's look at some case laws. First is Wog versus Carver. Some persons shared the profits of a business. The question arose whether these persons were partners or not because of the sharing profits. The court held that sharing of the profits is a prima facie evidence of partnership. Second case is Cox versus Hickman. A partner assigned his shares to another person. He shared the profits of the business and the firm incurred loss. The court held that the assignee was not liable because he was not a partner. This case was a death blow to the sharing of profit test, which was in vogue for nearly 60 years. According to this case, three principles are essential to find out the existence of partnership. They are by whom the business was carried on, by whom the liability was incurred, and under whose management the profits are made. Another case law is Mullow March and Company versus Court of Madras. A creditor advanced a loan to a partnership business. He also shared the profits of the business. The court held that the creditor was not a partner even though he shared the profits. In this case, the following principle was laid down to find out the existence of partnership. That was, the real intention and conduct of the business must be considered to decide whether they are partners or not. This is known as the intention and conduct test. Thus, Section 6 of the Indian Partnership Act lays down the rule in Mullow March and Company. So, the real relationship, conduct, and intention of the partners are important to decide the existence of a partnership. And the last mode is mutual agency. Section 4 of the Indian Partnership Act says that the business may be carried on by all or any of them acting for all. This clearly establishes the principle of implied agency as a test to find out the existence of the partnership. The partner who is conducting the affairs of the business is considered as the agent of all the other remaining partners. The relationship between them is governed by a law of agency. This concept of mutual agency is a true test of the existence of partnership. This relationship of principal and agent distinguishes a partnership business from a co-partnership, a joint in the business, as well as an agreement to share the profits of the business. Let's look at another case law for mutual agency, that is Stoker versus Brocklebank. The defendant agreed to pay 40% of the profits of his business to the manager. The court held that in this case that the manager was only a servant and not a partner as there was no mutual agency among them. And with this, I come to the end for today's session. Thank you.